Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now take a look at this. Ripple versus SEC Judge Netburn advances XRP lawsuit with new scheduling order. The ongoing legal dispute between Ripple Labs and the United States Securities and Exchange Decisions issued a fresh scheduling order. The recent nomination of Judge Netburn to the position of district judge in the Southern District of New York has not affected her role in the Ripple vs. SEC case. She has continued to preside over the case, during which she has earned a reputation for rendering decisions that are fair. Within the cryptocurrency world, this is regarded as an encouraging indicator, taking into consideration her previous decisions regarding this matter. On the final date for the SEC to respond, a respected pro-crypto judge named Judge Netburn was appointed to rule over the lawsuit between Ripple and the Securities and Exchange Commissions. Following this nomination, the CC was granted an extension until April 29, 2024, to file their opposition to Ripple's request. After this, Ripple will have 3 business days to respond to the request. The ongoing legal battle between Ripple and the SEC is showing no signs of abating, and it is more heated than ever before. The nomination of Sarah Netburn to the position of district judge in the Southern District of New York's Dani has become a significant development in the legal landscape. Ripple may emerge victorious in the case between the SEC and Ripple, which Netburn is currently in charge of supervising. Her favorable attitude toward cryptocurrencies and her reputation for rendering impartial decisions could be the deciding factor. An appointment that is crucial. The nomination of Netburn comes at an extremely important time. Ripple's unresolved battle with the Securities and Exchange Commission set, and especially Ripple's unwavering opposition to the SEC's substantial fines, brings to light the significance of her job as a judge. Ripple has recently taken legal action in which it has vigorously challenged the exorbitant demands made by the SEC and has offered a counter proposal of a maximum penalty of $10 million. Ripple appears to be in a strong position, as evidenced by the fact that it has presented 3 compelling arguments that challenge the charges made by the SEC and highlight changes in the way XRP is sold. Ripple may stand to gain a great deal from the anticipated court judgment, particularly if it is implemented under the supervision of Judge Sarah Netburn. However, if Netburn decides to side with Ripple, the SEC may experience significant difficulties, which will make it difficult for them to overturn her decision. Remarks from legal professionals: the nomination of Netburn has been met with considerable applause from professionals in the legal field. Netburn received praise from Paul Grewal, the chief legal officer of Coinbase, who emphasized her extensive knowledge of the legal issues that are associated with cryptocurrencies. In the context of Bitcoin litigation, Grewal emphasized the significance of the role that skilled judges play. Congratulations are for Sarah Netburn, who now serves as a United States magistrate judge in the Southern District of New York, as she has been nominated to serve as a United States district judge on the same court. To educate crypto and other individuals on the significance of having outstanding judges in the administration of justice, she has organized a master class workshop. Netburn's nomination was also praised by Bill Morgan, a notable supporter of XRP, who cited her impartial decisions and her skillful management of the SECVs. Ripple case has reasons for her praise. Morgan's endorsement highlights Netburn's esteemed judicial integrity and ability, indicating that her appointment to district judge is well-deserved and could be beneficial to Ripple's legal position. Morgan's support also indicates that their relationship is a good one. In the meantime, Ripple has issued a move to Magistrate Judge Sarah Netburn, specifically requesting that the SEC's expert documents be excluded from consideration. As part of the remedies case, Ripple asserts that these essential papers came to light. These records show the inability of the Securities and Exchange Commission to produce a supplemental expert opinion on disgorgement, as well as an essential declaration made by Andrea Fox, an assistant chief accountant for the SEC. As a result of this lack of information, Ripple contends that they were robbed of the opportunity to effectively dispute the points presented by the SEC. In addition, Ripple criticizes the Securities and Exchange Commission's classification of Fox as a mere summary witness, arguing that her analysis makes her an expert whose opinions ought to have been disclosed earlier. As a result of the CC's opposition to Ripple's request to be excluded from the process, the calendar for the subsequent sessions has been revised. Ripple's motion might have a big influence, potentially changing the SEC's view on remedies and impacting the larger conclusion of this high stakes case, which would affect the cryptocurrency industry as a whole. The outcome of this case could have consequences for the whole cryptocurrency industry. By the deadline of May 6th, the Securities and Exchange Commission is scheduled to file its reply brief. Parties and third parties have until May 20 to oppose the sealing of details contained in the filings. Would it be possible for Ripple to finally see a light at the end of the tunnel if they had a judge who might be sympathetic to their case and good arguments? In all honesty, only time will tell. Ripple's petition to reject the SEC's new expert submissions, which seek to bolster the SEC's case for remedies and a final judgment, is addressed in this order, which is a very important ruling because it addresses the motion. Ripple continues to take a firm stance against the Securities and Exchange Commission, exceeding its legal mandates. The current arguments in the case between Ripple and the CC, Ripple had challenged the proposed civil penalties that the SEC had offered, claiming that a settlement of $10 million would be more appropriate than the $2 billion that the SEC had requested. However, Ripple contends that the charges made by the SEC are exaggerated and do not have adequate proof to back them up. In addition, Ripple has contested the basis for disgorgement that the SEC has established, stating that there is no meaningful proof of financial harm that has been caused by Ripple's conduct. In addition, the defendants have used the Govel case as a means of providing support for their position. This case emphasizes the absence of proof for any potential future infractions or reckless behavior in the corporation's institutional XRP sales. The argument put up by Ripple is that any disgorgement estimates ought to take into account reasonable business expenses. The claim that Ripple's on-demand liquidity, OS sales do not represent investment contracts, as the Securities and Exchange Commission asserts has been an essential component of the company's defense. Customers keep on to XRP for only a few seconds to ease making payments across international borders. This indicates that the major use of ODL is for transactional purposes rather than investment objectives. Ripple's argument is based on the assertion that XRP was not designed to be used as a commodity for investment purposes. The SEC's classification of XRP as a security can be disproved by arguing that this argument is the most important. Ripple attempts to dismiss the Securities and Exchange Commission's demand for disgorgement and substantial civil penalties by reiterating its assertions that the SEC has not demonstrated reckless behavior or a high possibility of future violations. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making a decision about investments, we strongly advise conducting independent research and after consulting with a knowledgeable professional.